Both are kind of our procedures. Hello again, everyone. Good afternoon. Welcome to the Landlord Tenant Resource Center training on our operations, as well as an introduction to landlord and tenant practice. My name is Paul DeBlasi. I'm the managing attorney for housing, and my pronouns are he and him. I'm joined by Kate Rum. Introduce yourself, Kate.
Sure. Hi, everyone. My name is Kate Rome. I am the Pro Bono Support Attorney for housing here. My pronouns are she, her. I'm happy to have you all here today.
And I think that we might just, I know that not everyone who registered is here quite yet, but we might just want to, this is being recorded, and so all of you will be able to review this afterwards on our YouTube channel, and we'll also distribute this afterwards. Maybe we'll begin just for the sake of time. Please feel free to ask questions during the course of the training, but there'll also be an opportunity at the end to ask questions as well. And with that, I think I'm going to hand off to Kate, who's going to get us started.
All right, so thank you everyone for joining today. We are going to get started with Landlord Tenant Resource Center operations training. All right. Thanks, Paul. So we'll start off with just some basics of what the Landlord Tenant Resource Center is. So the Resource Center is a line, it's a phone line and an in-person line that stems from the Landlord Tenant Legal Assistance Network, which you might hear called LTLAN. So through LTLAN, tenants can get legal advice, brief service, possibly connected with representation. The services are a bit more expansive, and there are certain criteria that tenants have to meet to qualify for LTLAN. LTRC, on the other hand, is our very broad resource center for pretty much all tenants. It is legal information only. Volunteers can assist with filling out some legal documents, and we can certainly take a look at some documents if our tenants bring them into in person. We'll talk about that later. But it is really important to know that LTRC is legal information only. As I mentioned, we're both a hotline and an in-person service, and we are staffed by volunteer lawyers. I see some of our wonderful volunteers here today, and Pro Bono Center staff. You might see myself or Paul, or two of our other colleagues, Megan or Amha, on your shift. So a little bit about our callers and who our population that we're serving is. DC has over 700,000 residents, and about 16.6% of those residents live below the poverty line. And when you're in LTRC, you'll probably see that a lot of our callers are around that, even though they might be making a bit more, they're still around the poverty line, right? So we're dealing with a lot of people who live in poverty. In DC, age demographics, we've got over here, you've got a vast majority of people in that 18 to 35 range. Right now, average rent is about $3,275 for a 2-bedroom apartment in DC. But the average income for a family of 4 is $142,300. So you can imagine that after taxes, you're probably looking at about like $9,000 take home. So your family is now spending over 30% of your income with that average rent on renting alone. And that's for a family with the average income. We're not even talking about those who are living around the poverty line. For a family of 4 in 2022, just to put that in some context, the federal poverty line was $27,750 per year. That's how much the family of 4 makes per year. So you can imagine that if a family making $142,000 is spending over 30% of their income on rent, a family making even less than that might be spending the vast majority of their income on rent. And then the last demographic that we do want to touch on, as you all probably know, DC is a very diverse city. We are one of the few large cities that has demographics like that. So we are nearly 50% white, nearly 50% Black, and most of our tenant population do fall under the Black category. So what qualifies you to come and talk to us in LTRC? So tenants, like I said, any income. However, you do have to have a specific type of issue that you're looking for. So we see a lot of housing conditions, we see a lot of evictions, but we also see a lot of self-help and illegal lockouts. Those go hand in hand pretty frequently. Um, we can also talk to people who have issues with getting their records sealed, people who have questions about the emergency rental assistance program, talk about that a little bit more later, and also voucher terminations. We do talk to very limited landlords in LTRC. So we talk to small landlords, and that means someone who has fewer than 4 units and no property management company, and of course, no lawyer. They must have an active case, or it has to be a case closed from the past year. I actually think we've had to limit that recently to even shorter. It might be a case closed within the past 60 days, but the case that's been closed has to be pretty recent for us to be able to talk to them. And now we'll talk a little bit about volunteering in LTRC.
Thank you, Kate. Yeah. So, as Kate said, we talked about volunteering in the LPRC. And to volunteer with the LTRC, attorneys must either be members of the DC bar, be members of another United States bar, admitted into another United States bar, or awaiting bar results with a dean certification from their law school. And it's important if someone isn't licensed in DC to let the person you're assisting know about that. In terms of remote volunteering, a person who is volunteering at LTRC remotely will need a computer, and they'll be using the computer to use Litify or case management system, view dockets online, and communicate with Pro Bono Center staff and persons seeking legal assistance. They'll also need a Litify account, which is the case management system that we use for the LTRC. And someone volunteering will receive an email from the LTRC supervisor, a Pro Bono Center staff person on the day of their shift, typically around 9 a.m., with instructions on setting up a Litify account. And once a Litify account is created, then there'll be a Litify account associated with that volunteer going forward. And also a phone, which can be their own, an office phone, or even an app like Google Voice, which will be used to reach out to the persons that are seeking legal assistance. And shifts for the remote LTRC, which are 5 days a week, are from 9 a.m. to 2 p.m. And we ask that if a volunteer is not available during any portion of their shift, to please let the contact the firm, and certainly let also the Pro Bono Center staff supervising know. And if someone's volunteering, they can expect to speak to 2 to 4 persons seeking legal assistance during their shift. And over the last year, we've had an uptick in the number of people that are getting assistance through the remote LTRC. So certainly, talking to 4 persons, maybe even 5 persons, is certainly something that can be expected to occur. All caller assignments will go to the case management system, Litify. And through that, if someone's volunteering, they'll have a screen with all the intakes assigned to them, and they can click on one of those intakes to get a caller's information, such as a brief description of the reason for calling, and guidance from the supervisor about how to proceed to provide assistance to that person, as well as potentially any kind of documents or forms that might be useful for providing assistance to the person seeking help. If a volunteer has questions, they can let the caller know that they'll call them back, and then they should check in with the LTRC supervisor. And definitely, there will be guidance coming from the LTRC supervisor. And while it's important, I think, for all the volunteers to have some kind of framework, which part of what we're doing here, to give a framework in practice in landlord tenant to help with interviewing and providing legal information, to tenants and small landlords. It's still the supervisors there is the expert on the substantive law and is a resource not only to give guidance up front, but also to answer any questions the volunteer has. So really, as a volunteer, volunteers should not hesitate to reach out to whoever's to the LTRC supervisor with any questions they might have about how to best assist the person that they're speaking with. And as you can see here, the options that the volunteer has is they can tag the supervisor in chatter, which if once someone's logged in to Litify, they can see there's basically a way to post communications within the case management system and then the person's gonna be tagged with that, and then they'll both see that in Litify and see that and receive an email notifying them of the communication, or just sending an email or giving the supervisor a call on the phone. And all those would be great ways to answer any questions that a volunteer may have. And as we'll talk about, as Kate will talk about a little bit more later on, remote volunteers are only providing legal information. They're not providing advice, and certainly not any legal representation to the person seeking legal assistance. And here, this is just demonstrating the screen, one of the screens I was just talking about. When a volunteer signs in to Litify, this is sort of their home screen where they'll see all the different intakes that have been assigned to them. And so here, this person has 2 intakes assigned to them, and they can see here that the supervisor for that day is Kate, which so they're in good hands. And just this is often counterintuitive. The volunteer can look at any of these cases by clicking on the case number, the INT dash long sequence of numbers. That's the way to look at the intake and to proceed with getting information about the intake and to call the person to give them assistance. You can click on the client name or the name of the person seeking legal assistance, but that will not lead to that screen. It'll lead to a different screen, which is less helpful in terms of trying to help that person. And then if you were to click on the intake number, again, not the name of the person seeking assistance, but the intake number, then this is the other screen we're talking about, where you can see that there's information about the person seeking assistance. You can see that there's a case number, which could be used to look up the case online and look at the events in the case, as well as documents filed in that case. Below, you can see the instructions to the volunteer, where there's specific guidance provided by the supervisor to the volunteer about how to proceed with providing legal information to assist that person, and then maybe also highlighting some questions or resources that might be also useful to figure out how to best assist that person. And then further down, there will be description of what was the issue that was being raised by the person seeking legal assistance, and the chatter that I discussed, where there could be communication about with the supervisor about what's going on in the case. There's also, as you see the upper right-hand corner, a place to note whether contact was successful or not, and to make notes about that. Apologies. And certainly and that's part of what, anytime that you're trying to reach someone, you'll be, as a volunteer, you'll be marking whether you were able to make contact successfully or not each time you reach out, and an option to also send emails, which will often be used to provide documents or other useful information, documents, potential forms, templates to the person seeking legal assistance at the end of the interview. And some FAQs for remote volunteering is that if the caller is looking for representation, as we've already mentioned, the LTRC cannot provide representation. Occasionally, the Pro Bono Center can accept tenants who meet certain requirements for referrals to the Advocacy and Justice Clinic. And so the LTRC supervisor will determine if a caller should be referred. But certainly if that's something you could raise with the LTRC supervisor. If the caller does not speak English, usually if a caller primary language is not English, the LTRC supervisor will be aware of this, and they'll let you know to use language line and which language is the preferred language for that person. But if for whatever reason you just discovered that English is not the best language to speak with that person, then you can reach out to the LTRC supervisor for language line instructions, which can help you get an interpreter, a telephonic interpreter to speak to that person. If the caller needs more help than just a phone call, refer to the LTRC supervisor who will assist with directing the caller to further legal assistance that might be able to help them, including potentially our in-person resource center. And if the caller needs a follow-up email, what I was referring to earlier, then you can send a draft. The volunteer can send a draft that email to the LTRC supervisor for approval before sending through Litify. And for in-person, we have also the in-person Landlord Tenant Resource Center, and that's open at the Landlord Tenant Courthouse. It's on the second floor in room 223. It's open on Tuesdays from 10 a.m. to 1 p.m. Although volunteers can expect to work with the person seeking legal assistance until around 3 p.m., although it varies depending on the day and how many people are coming in. And there is a brief training on in-person procedures for new in-person volunteer attorneys at 10 a.m. So again, we're asking volunteers from in-person to arrive at 10 a.m. to our office at the Landlord Tenant Courthouse. For volunteering in person, you'll also need a laptop to access Litify, a phone, and also you can use the laptop to look up cases online, a phone to potentially, to assist with communications, although it's less important than with remote LTRC, and to address the schedule. Like remote LTRC, you'll have a script to read through when you first meet with the person seeking legal assistance. And at LTRC, you will check in person. You'll check in with LTRC supervisor at least twice, once before meeting the person seeking assistance and once more after the initial conversation. And just like with remote LTRC, the volunteer can certainly should speak with the LTRC supervisor as often as they need to make sure they get the best information to the person seeking assistance. But with in person, there's not only a check-in beforehand, but also a kind of check-in before we let the person seeking assistance go with whatever information and documents we think can help them. Volunteer attorneys may take a lunch break between speaking with person seeking assistance. That isn't like a particularly scheduled time. It's just whenever makes sense between intakes during the course of the day. And in volunteering in person, the volunteers provide legal information and limited brief services. So like remote, some people only need legal information, but some may need assistance completing documents such as housing additions, calendar complaint, or an answer in a non-payment rent case. And some may need help interpreting a document such as a notice or a lease. And at the end of the meeting with the person that the volunteer is assisting, then the volunteer will have a form to fill out and give to the person that contains a summary of what they talked about, similar to a follow-up email Litify. And that's part of what, when a volunteer checks in with the LTRC supervisor, part of what that LTRC supervisor will approve is the contents of the notice, as well as whatever documents were generated during the course of meeting with that person. And now I'm going to hand this back to Kate to talk a little bit about legal information versus legal advice.
All right, thanks so much, Paul. So yeah, this section is going to talk about the difference between legal information and legal advice. It can often be a pretty thin line. So we're also going to go over some examples just to give you some ideas of some pretty common situations that come up. So legal information, first up, what you can do is explain the law. You can explain court rules or court procedures relevant to the caller or the person who's in person's issue. This can include how to effect service. How do I file something? What do I request at an initial hearing? Burdens of proof, all those types of issues. You can explain what to expect in court. So if you're going to an initial hearing, what should I expect to happen? Or who's the judge going to be? What's opposing counsel? Things like that. You can explain court forms and documents. If you volunteered with us before, you probably know that we have a lot of pro se forms that we give out to our tenants. You can go through those forms with the caller. You can explain what parts they have to fill out, all of that. You can also explain pros and cons of options available. So you can explain one of the most common ones that we have is a jury trial versus a bench trial. And we'll get into that later on. And you can also explain potential outcomes. Legal advice, on the other hand, is applying the law to the facts of the caller's case, right? Literally analyzing their case, suggesting likely outcomes or likelihood in general. So I know that's a little weird as compared to probable or, possible outcomes. When we're talking about possible outcomes, we're talking about all of the possible outcomes. We're not talking about, well, it's likely that the judge will do this. So foreseeable outcomes and how that might impact the caller's goal, typically we don't want to be talking about that. And then finally, offering an opinion on a caller's options. Please do not offer your own opinion. Please do not phrase it as advice. That's really important. So now we are going to practice. If anyone is brave and wants to put in the chat, we're going to have some option A, option B. You can do that, or you can just think about it to yourself. You don't have to do that out loud today, but after going through your initial conversation with a caller who has an initial hearing and an eviction case coming up, the caller says, so I can choose a jury or a bench trial. Which one should I choose? And you're going to have two response options here. Think. Sorry, Paul, I think if you hit the space bar, the two options should come up. Let's see. Yes, there we go. So these are your two options now. So we have, unfortunately, I can't tell you which to choose. I can talk you through the potential outcomes for each of these, or based on your situation, I would choose a bench trial because you want to be done quickly. So think about that for about 30 seconds. All right, Paul, do you want to hit the button and show us the answer? It'll be A. So thank you, Nick. Yay, we love someone who can. Thank you for being brave and putting that in the chat. So A is correct. Anytime someone asks you for your opinion, like we just said, or asks you to advise them, please remind them, unfortunately, I can't tell you which to choose. I can't give you advice, but I can talk to you about the potential outcomes, the pros and cons for each. All right, we'll go on to the next one. So you let them know, can't tell them which, but then you talk them through their options. Your caller then says, okay, I think a bench trial is better for me. Do I need to file anything? And what would you file? So you have a couple of options here. You might respond, you should file an answer. An answer presents your defenses and allows you to explain to the judge why you don't think you should be evicted. Or tenants can always file an answer, which presents possible defenses and allows a tenant to explain to the judge why they don't think they should be evicted. All right, same deal, give you guys a little bit of time to think it through. And if anyone wants to pop it in the chat, please feel free. Shirley, thank you for participating. We love to see it. I'll give everyone a little bit more time. All right, Paul, let's reveal the answer here. It's B. That was right, Shirley. So I know, especially when we're talking in person, using you can come up very frequently. As much as possible, as much as you can remember, please try to phrase it as tenants and use it very generally. It helps keep it in the category of legal information and broad as opposed to legal advice. All right, next one. You explain the answer and the caller says, can I get a copy of an answer? I don't have email and technology is really difficult for me. So a couple options here. You can say, yes, we have in-person services available at the courthouse that can help you with the answer. Or yes, you can find hard copies of answers at the Landlord Tenant Branch's clerk's office located in Court Building B. So I will give everyone another couple seconds. Think about this one. All right, Paul, let's reveal this one. Okay, this one was a trick question, so I understand why no one was brave in the chat. It's both. Both are totally acceptable options here. You can always check in with the LTRC supervisor beforehand. I would strongly recommend checking in with them beforehand just to make sure that we will have a copy of this in person. But for the most part, anyone who has difficulty receiving something over email can come in person and we'll print it out for them. We can even help them fill it out in person. And these are just a few common abbreviations or terms that you might see us use as supervisors, or you might even see callers use. We're typing super quickly, so we're trying to get these things out quick. So if you see these abbreviations, know that's why. And for the callers and tenants, this just might be what they know it as. So DCHA or North Capitol, that's DC Housing Authority. DCHA used to be located on North Capitol. The headquarters has since moved, but a lot of people still know it as North Capitol. Section 8 is really a catch-all term. It can be used to describe a number of housing subsidies. If you are ever not sure what type of subsidy is going on, please check in with the supervisor. We have a lot of resources that we can check what type of subsidy there is. Voucher almost always refers to the Housing Choice Voucher Program, which is a portable voucher used anywhere in the US. Whereas project-based or site-based Section 8 is a federal subsidy that stays with the unit as opposed to traveling with the tenant. And then the last one that you're going to hear really frequently is ERAP, and that is DC's Emergency Rental Assistance Program. And then a couple that we use all the time in our notes. HCC means Housing Conditions Calendar. That's where tenants can go to sue their landlord for repairs. LT, landlord tenant, every time. DOB is formerly DCRA. Lots of letters to mean the Department of Buildings. That's the government agency that goes out to inspect tenants' homes. A TRO is a temporary restraining order. A PO is a protective order. And then the one that we use truly every single time is LL, which is landlord. All right, and that is the end of this portion of the training. If anyone has any questions, you can always email either of us or stick around, and I think we can answer questions at the end of today's training.
Thank you, Kate. So I'm just going to transition to our next slide. Again, we're transitioning to going from the procedures for the Landlord Tenant Resource Center to talking about landlord tenant practice, which is the most common area that comes up in the context of helping people through the Landlord Tenant Resource Center. So just bear with me a moment. Nope. There we go. Actually, Kate, am I sharing the right thing now?
That's the right thing. Yep.
Sorry. Okay. Yeah, and so again, we're going to talk about introduction to landlord tenant practice, and I think Kate, you're starting off, right?
Sounds good to me. All right. So a little bit of an overview of what we're going to go over in this part of the training. We're going to understand basic concepts and legal authority that apply to evictions in DC. Understand where persons seeking legal information from LTRC may have to appear in superior courts. There are a few different branches they might go to. Understand parties' options in an eviction case, options after a judgment is entered, And then finally, we're going to do another practice on how to interview and provide legal information in a client-centered way. So first up, really important in DC, a tenant may only be evicted through court process. This means that any attempt to evict a tenant without going through the court is considered a self-help eviction and is illegal in DC. That comes up very frequently with our callers. Another important concept is that tenancies in DC can be created through a written lease, an oral agreement, or an implied contract. So you do not actually have to have a written lease to be a tenant in DC, and we do have this happen pretty frequently. A tenant, a subtenant, or any other person who is entitled to occupy the home can also sue their landlord for injunctive relief and damages if the landlord does that self-help eviction, changes the locks, takes the tenant's property out, or cuts off utilities. Those are some of the really common self-help eviction methods that we see. And in addition to not being able to be evicted by the tenant themselves, DC has a list of very specific reasons why a tenant may be evicted, and those are the only legal reasons for eviction. Really important here, a landlord cannot evict a tenant because the tenant's lease expired. So once a tenant's lease expires, they actually automatically become a month-to-month tenant in DC. The landlord does not have the right to kick them out. The tenant can stay. Now the landlord can raise the rent and other things can happen, but the tenant has the right to remain in the property even once their lease expires. And a landlord must give the tenant an appropriate letter or notice before they file their eviction suit. So those are most often in LTRC going to be 30-day notices, but every once in a while we do get a more extensive notice. Your supervisor will absolutely tell you how long the notice needs to be depending on the reason, but you can find all of the notice term requirements under DC Code 42-3505.01. That code section, just so you all know, is where the vast majority of the beginnings of eviction law is. So if you ever want to take a look at it, it's a great one just to read through. The notice that the landlord sends, be it the 30-day, 90-day, 180, whatever it is, also has to meet requirements for its content and how it is served. For the 30-day notices that we see most frequently, we have samples, and you're able to look at those samples to see what the content should look like. Generally speaking, there are a few things you should have, like the tenant's name, if it's non-payment of rent, how much they owe, what date they need to pay it by, just some basics. And finally, the landlord also has to submit a copy of that notice along with a bunch of other documents with their complaint. So notice is really important, and it is condition precedent to filing an eviction case. Here is a list of where all of our law comes from outside of case law. So we have DC Code, like I said, that one section is really going to be where you want to start with evictions. The Code of Municipal Regulations as well. Title 14, I believe it is, that's where the vast majority comes from. You also see a lot of housing code in that part of it. Also US Code 42 USCA 794, and then finally the Code of Federal Regulations in 24 CFR 8.1. We also have the rules of the Court of Appeals, the Superior Court rules of civil procedure, the rules for landlord tenant branch, and occasionally the rules of procedure for the small claims and conciliation branch. If you're ever wondering what rules apply, the rules are available online. You can also absolutely check in with the supervisor, and we can actually send you little PDFs of the rules. Thank you to Superior Court for that. We also rely on general orders, supplements to orders, and administrative orders. Housing Conditions Court in particular really relies heavily on administrative orders.
Thank you, Kate. So now we're going to talk a little bit, we're going to focus a little bit more on what we've already begun talking about, DC Superior Court, which is one of the main venues, not the only, but one of the main venues where landlords and tenants may seek relief, or seek to avoid relief, as the case may be. So here we have a sort of a schema of a DC Superior Court and the different branches and divisions that most often affect the landlords and tenants that we're providing assistance with in the Landlord Tenant Resource Center. So again, here are the courts for tenant and landlord disputes in DC Superior Court. Landlords and tenants may bring legal disputes to several different branches and calendars of the Civil Division of DC Superior Court. The Civil Division is one of several different divisions of DC Superior Court. The Court of Appeals of the District of Columbia takes appeals from all of these courts. And we're going to talk about these different branches of DC Superior Court in a little bit more detail. As you can see, here the Civil Actions Branch, which is the court sort of general jurisdiction for civil claims that are over 10,000 or involve equitable relief, also includes the associate judge calendars. And when we talk later about cases being certified from Landlord Tenant Branch to associate judge calendars for jury trials, that's where they are. And housing nuisance calendar, the calendar that Kate was talking about, is also a calendar of the Civil Actions Branch, even though it acts sort of like its own thing, so to speak. But going into the Landlord Tenant Branch is not the branch where landlords and tenants can resolve all their disputes. It's really a branch for plaintiffs to kick defendants out of their homes or of their business or their place of business. Although in the Landlord Tenant Resource Center, we're only assisting residential tenants and small landlords that are in residential tenant cases. So in the Landlord Tenant Branch, plaintiffs may seek possession of real property from tenants, for close homeowners, and other persons alleged to not have a right to possession, which could include, persons that allegedly broke into the property or overstay, guests overstaying their welcome, or some other situation like that. A tenant who has been sued, the court enters a judgment for possession that allows the eviction to proceed if a plaintiff prevails. And this is earlier when Kay was talking about not like evictions being unlawful unless they're authorized by the court. The Landlord Tenant Branch is how an eviction becomes lawful in the District of Columbia, where the plaintiff prevails on the merits or in some way, or gets a settlement agreement and then there's a breach of it, or in some way gets a judgment for possession, which then allows a process that continues to having the locks changed on the person and having them removed from the home. A tenant who has been sued for non-payment of rent may counterclaim against their landlord for money judgment and injunctive relief. And so injunctive relief, that usually means getting repairs done to the home. It could also mean potentially getting restored to the home if the defendant or the tenant's unlawfully locked out before there is a judgment in the case that allows or authorizes the eviction. Money judgment would be, and we'll talk about this in a little more detail later, would be a judgment against the landlord allowing the tenant to collect because of the landlord's liability to the tenant for failing to repair the home. And related to that, the court may enter a money judgment in a non-payment of rent case if the tenant was personally served or if the tenant filed a counterclaim for money judgment. So generally, the remedy that plaintiffs have in the Landlord Tenant Branch is just a judgment for possession, a special judgment that allows them to kick someone out of a home. But under these limited circumstances, they could also potentially get a money judgment, which would allow that plaintiff to collect, or in this situation, really, this landlord in a non-payment rent case, collect that money in other ways, such as garnishing wages or going after a property held by the defendant. And we're going to really focus on Landlord Tenant Branch during this presentation. This is focused on landlord tenant practice, but other common forums for tenants in DC Superior Court, as we just talked about, is the housing nuisance calendar for the Civil Actions Branch, which is where a tenant may file a complaint seeking to have the landlord address housing code violations, and in which the court may award injunctive relief and sanctions, but not monetary damages. And we talk about that more in a different training about affirmative rights the tenants have. And the Small Claims and Conciliation Branch is where a tenant or landlord may seek monetary damages equal to or less than $10,000. And that, sorry, it's typo, the court does not award injunctive relief, not now. So well, small claims conciliation branch is only about money. And we have a different actual clinic of the Pro Bono Center that provides assistance to persons that either have cases in the small claims or are seeking to file small claims, and we can refer those persons to that clinic for assistance if that's the situation. And now I'm handing this back to Kate to talk about practice and procedure in the Landlord Tenant branch.
All right, great. So now we will be talking about how these cases are handled and the chronology of the eviction case. So first up, courtrooms are handling cases remotely and in person. It's very much a hybrid model right now. So any of the landlord tenant branch courtrooms that you go into, the judge will be in person in the courtroom, but litigants can appear by video for quite a few of the hearings. Typically, trials, bail hearings, those evidentiary style hearings are in person, but it'll usually be indicated on the hearing notice whether or not it's in person or virtual. And there are public access links to every courtroom. If you ever want to observe, you are more than welcome to as a member of the public. We also have court forms and some pro se pleadings on the court's website. If you're ever not sure where to find a court form or pro se pleading, just check in with the supervisor because we have all of them ourselves and we can get them to you easily. And also important is the court's portal search. If you want to take a look at the case online, we'll always put the case posture in our notes to you. But if you just want to give it a look yourself, that's where you can find it. And some other resources that we have available are on lawhelp.org and probono.net. We manage both of those websites and we put a variety of helpful resources on them for you. So the eviction case. How are landlords bringing tenants and defending against eviction cases in DC?
Thank you, Kate. So in terms of starting an eviction case, a landlord must have a current license for rental housing and a valid registration or claim of exemption filed with the Rental Accommodations Division of the Department of Housing and Community Development. And the Rental Accommodations Division of the Department of Housing and Community Development that's the agency that overlooks rent stabilization. But even if a unit is not rent stabilized, one way or the other, any rental unit has to be registered with that. And so that's where that document comes from. And then, as I said before, you also have a valid license for renting a home. A landlord must serve the required notice on the tenant in the required manner. And we'll get into more detail about that, but there's specific requirements about how that notice is served. And a person that a plaintiff alleges is not a tenant may not be entitled to notice. So for most eviction cases, in any eviction case, really almost any eviction case against a tenant, as Kay was describing earlier, there's a requirement to give a notice and to serve it a particular way prior to filing the lawsuit. And often to time, that notice involves also an opportunity to address the issue and avoid the lawsuit. But if a person is allegedly not a tenant at all, then no notice needs to necessarily be given to that person before a lawsuit is filed. Here we can see in the column on the left, the requirements for serving the notice, which even if the content of the notice might vary a lot in the requirements, as Kate was describing, the way that it must be served does not vary. And on the right-hand column, we see the requirements to serve the complaint summons, which is very similar, not identical, but very similar to the requirements to serve the notice. So on the left, we see that the landlord may serve the notice on the tenant in person. They also may serve the notice on another person of proper age upon the premises, so someone who's not a child. They may serve the notice by posting on the door and mailing by first-class mail within 3 days. So first, it needs to be posted on the door, not slid under the door, not wedged into the door, posted on the door, and then mailed by first-class mail within 3 days. And if the last choice is the one that the landlord chooses for serving the notice, then they also, when they file a complaint afterward, when and if they file a complaint afterwards, they need to file a timestamped photo of the posted notice with the complaint. And here, for the notice, a landlord may do all this themselves. So a landlord may personally hand the notice to the tenant. They may personally hand the notice to someone else who resides there that's not a child. They may mail it themselves. But a landlord may not do that for someone's complaint. For someone's complaint, a landlord must get a process server or potentially a friend and family member, although maybe not a partner or spouse, to serve that. And for the complaint, we see it's very similar, right? Like a complaint and summons may be served on the tenant in person, may be served on someone above 16 years of age that resides in the premises, may be posted on the door and then mailed afterwards. And if it is posted, again, the photo needs to be taken, which is going to be attached to a declaration of service that needs to be filed with the court. And that proof of service, the declaration of service of the summons and complaint, must be filed at least 21 days before the initial hearing, or there's a risk of the case being dismissed. And here we can see just like a little timeline that talks about, that presents the procedure in a Landlord Tenant Branch case leading up to the initial hearing, which is the first hearing in the case. And that is not a trial. It isn't like, it's not, it's really sort of a hearing that allows the tenant to respond to the landlord's complaint and the allegations they've made against them. So again, there's eviction notice that must be served. The eviction and complaint filed after notice expires, which is Kate was saying, maybe 30 days or maybe longer, depending on what's the substance, what's the requirements for that specific reason to evict the tenant. After the eviction complaint is filed, and then the complaint summons must be served on the defendants. And the landlord must file a declaration of service with the court at least 21 days before the initial hearing, and then for the initial hearing. And here we can see some of the options, or the majority of options, that are of how initial hearing or a further initial hearing may go. And a further initial hearing is really just a name for an initial hearing that happened after the first one. So where the options are basically identical, except for the fact that it's much less likely that a tenant's going to get a continuance after the initial hearing, especially if the continuance is to find an attorney. So here, again, we can see the options. One is a tenant may request a continuance to a further initial hearing. And oftentimes a tenant can seek a continuance. Well, they can seek a continuance for a variety of reasons, but if they seek a continuance to find an attorney to represent them, but they're not represented yet, then that's a reason that the court will, that's a reason that the court will find is good reason to give a continuance, at least once. The tenant can also make an oral motion to dismiss if there's some procedural issue that on the record that would be appropriate for an oral motion to dismiss. They could have a trial set before a judge. So if there's if the tenant presents some kind of reasons, or the judge determines there's some kind of reason why there might be a dispute about the allegations the landlord's made, then a trial will be set. We'll talk a little bit more about that procedure in a moment, what that'll look like. Or a tenant can file a written answer, setting a trial before a judge or certifying the case for a trial before a jury. And as I imagine many of like you all know, that answer would contain whatever defenses or reasons that the tenant has to say, or the defendant has to say that the landlord should lose the case. And notice here that in the Landlord Branch, a tenant actually doesn't have to file an answer to have a trial. Like it's not a requirement to file an answer. It is a requirement, though, to file a written answer if the tenant wants to have a trial before a jury and have all the different other procedural differences that are available in a jury trial. It is also possible at an initial hearing or for an initial hearing that the court might enter what's called a confess judgment against the tenant if the court determines that the tenant does not have any defenses to the case. And this might happen if the tenant hasn't filed an answer, and the court say, for example, asks the tenant why they didn't pay the rent, and the tenant doesn't raise any issues that would be a legal defense, such as maybe saying that they lost employment and not giving any other reason why they shouldn't owe that money. It's also possible the tenant may lose the right to a trial before a jury. A tenant at the initial hearing has the right to a trial before a jury. If they continue the case without reserving that right, then they can lose that right to a trial before a jury. And that is why it might be important for a tenant to, if they continue the initial hearing or any further hearings, to ask to continue the case, all rights reserved, so that they still preserve that right to a jury if that's something that they're interested in. And the court may discuss the agreement with the parties before entering it. So if there happens to have been an agreement entered before the initial hearing, which sometimes happens, and if the case has and if there's some issue what the court wants to address, then they might discuss that with the tenant. But oftentimes what happens at initial hearing will be the tenant will request a continuance will be granted, or a trial will be set of some kind, or there'll be an answer filed that will set that case either before a trial before a jury or before a judge. And here with this this graphic of what happens after the initial hearing, we can see the different ways that a case may fork, depending on whether the tenant chooses to proceed the trial before jury or with a jury demand or without a jury demand for a trial before a judge. And also here, there's a difference between if this choice was made at the initial hearing or at a further initial hearing, which would be similar to if it was made at a further initial hearing, or there could be depending on the case, there might be quite a few further initial hearings, which might be even more so now that with emergency rentals, if a tenant applied for emergency rental assistance, that's a basis to automatically continue any initial or further initial hearing or any other hearing in the case. So that might also lead to multiple further initial hearings as well. And so we can see that if a case is if a trial is set without a jury demand before a judge, then the case stays in the Landlord Tenant branch, and basically the court will set a bench date, a trial a date for the trial, and a date for mediation. And this is changing, to be honest, all the time as the court is trying to become more efficient with cases, with a hybrid calendar it has. But right now it would be probably a matter of months before that bench trial, if the tenant was to ask for have a bench trial set on one day. It'd be a matter of months for the bench trial. The mediation would be a little bit before that bench trial. If it instead a tenant or defendant asks for an answer for a jury, they make a jury demand and a trial before a jury, they make a jury demand in their answer. Then when that happens, the case will be certified to an associate judge in the civil actions branch, who will hear many but not all motions and matters related to that case. There'll be a close of discovery set, which will be which the parties can ask for more time or can agree to more time, but will probably be 45 or 60 days out, at least as a starting point. And that's a time period for which the parties theoretically would complete discovery, although it's quite common that if the parties do exchange discovery in a landlord tenant branch case, that it's not resolved within that time period, because it's often quite difficult I think my colleagues' experience to get adequate responses out of opposing counsel at that time. But regardless, a close of discovery would be set, and a mediation date would be set at the time that the answer is filed with the court and the case is certified to the civil actions branch. The next steps, though, would not be set at that time. So a pretrial conference would only be set if and when mediation fails to create an agreement, and then a trial would only be set after the pretrial conference. And there's all kinds of requirements for a pretrial conference that include the parties meeting to discuss a variety of issues that would be important for a pretrial conference, including, say, proposed jury instructions and exhibits and witnesses and limine matters and other issues. There's a deadline for motions to limine. There's a deadline for a joint pretrial statement that includes the side's positions on various issues, and all that has to go into a pretrial conference before a trial is set. So it's a much longer process, a lot more events, a lot more requirements. Then a trial that is going to be stay in the Landlord Tenant branch to be heard by a judge. And down here we can see the same sort of process with just and that it would have moved up a little bit if there hadn't been a continuance or further initial hearing. But these are the different ways of the case. These are some examples of how a case may go in the Landlord Tenant branch, depending on how a tenant wants to navigate their case. And then just to talk a little bit more about discovery, mediation, and trial. Just to reiterate these issues, when a trial is set without a jury demand, the court may set mediation, followed by a trial date. Witnesses and documents may be subpoenaed for that trial. So even when a case stays in the landlord tenant branch, the tool that are available under the rules are available, like tools like subpoenas are available. And the parties may even file a motion for leave to conduct discovery. There isn't a right to discovery with cases that are without a jury demand that are set for a trial before a judge, but the parties can still agree to that or file a motion, or a party can file a motion to get leave to conduct some discovery. And if an answer to your demand is filed, the court may set a close of discovery followed by mediation date. That's what we just discussed. As we discussed, an associate judge will handle most matters in the case, and trial will take place after a pretrial conference. And non-payment, and to talk a little bit more about non-payment of rent cases, and then sort of the go into more of the substance of non-payment rent cases. Non-payment rent cases, to prevail in a non-payment rent case, landlords must show the following. They must show that a landlord-tenant relationship exists between the plaintiff and the defendants. The defendants failed to pay $600 or more in rent to the plaintiff, and the plaintiff gave the required notice of past due rent to the defendants at least 30 days before the complaint was filed in the required way. And I want to bring up now a really important point is that a tenant may halt an eviction before a case is resolved by paying the rent the other alleges is owed. And this is both before judgment is entered, like a tenant can always pay what the landlord alleges they owe to stop the case. And even after the judgment is entered in a non-payment rent case, and we'll talk about this a little bit more later, a tenant may prevent an eviction by paying whatever the court has found that they owe. And that's why those judgments are called redeemable. And this is part of why emergency rental assistance can be is so important in non-payment rent cases. The Emergency Rental Assistance Program, ERAP, provides overdue rent to district tenants earning less than 40% of the area median income. Tenants may apply for ERAP at, well, here's this website, I'm not going to spell it out, but that's the website where they can apply. Although currently tenants can only apply on certain dates. So there's basically it's quarterly. The next one's coming up April 1st. When tenants can apply, and the last few times I believe the ERAP, like the city only takes a certain number of applications before it cuts off the applications, and that's all run out the day of. So people who don't apply for emergency rental assistance the day that it opens on this quarterly schedule, they don't get an application in, which I think is really difficult, obviously, for tenants in the district who are trying to get assistance with paying the rent. Tenants may also call this number or email to learn more about ERAP and to inquire about their application, but to be honest, for them to actually get it in, apologies. It will be difficult without, like one of the problems with the current system is it really benefits those who are speedy and nimble in terms of getting their applications in, or have assistance in getting their applications in, given the limited number of slots available. As I mentioned earlier, the court must stay non-payment of rent proceedings while a tenant's application is pending. And that's any proceeding, including an eviction that's scheduled. It has to be stopped. It can't go forward if it is a pending emergency rental assistance application. And a landlord must reschedule an eviction date when the tenant informs them of a pending ERAP application, as I just mentioned. Here, we're going to turn a little bit to non-payment rent defenses and counterclaims. And this is, and I know there's a lot of information. We're just going sort of quickly touch on some of the different defenses and other issues that arise in these cases. So in terms of affirmative defenses, or these defenses that a tenant can bring and has the burden of proof against the landlord's claim, they have the breach of implied warranty of habitability, which is alleging the landlord failed to correct housing code violations. And this is a really important part of the law in the District of Columbia that benefits tenants, that they can argue if their landlord hasn't fixed their home, that they don't owe as much rent, or maybe any rent, because of that failure to fix their home. And likewise, there's also void lease, which is a similar affirmative defense, but an affirmative defense in which the tenant is alleging that the landlord failed to correct unsafe or unsanitary conditions in their home. And as again, the remedy for that is a reduction down to potentially zero of how much the rent owes for the time period in which there were those problems that the landlord failed to address. And another affirmative defense that commonly comes up in non-payment rent cases is that the landlord sued in retaliation for the tenant asserting their rights, including perhaps, like, say, the tenant complained about conditions in the home, and then following that, the landlord sued them for non-payment of rent. The tenant could argue that that the lawsuit is retaliatory, and therefore, and giving the notice is retaliatory prior to that, and therefore the landlord should lose. Substantial defenses is just a term that we're using here to talk about when the landlord can't prove their case. So earlier we had their kind of prima facie case, right? So the tenant can disprove, or if it's, sorry, if the landlord can't prevail, can't meet their burden on any of those elements, then the tenant wins. So if the plaintiff can't prove that they're the tenant's landlord, the plaintiff is not the tenant's landlord. If the plaintiff can't prove that the tenant actually owes rent, maybe the tenant says that they paid the rent, or that the rent increases were illegal, or if the landlord served an inadequate notice, the contents of the notice is inadequate, which, sounds a lot like a procedural defense. And to be honest, I'm not going to pretend this is like a clear line, but here, since it's a requirement of the prima facie case, I'm putting it under one of the elements that if it's disproved, the landlord loses. Then go to procedural defenses. So if the notice of past due rent was improperly served, if required documents were not filed with the complaint, if the complaint was improperly served, those are example of procedural defenses for why a landlord might lose. And then below we have equitable defenses. So, and here's a way of thinking about defenses that don't directly relate to that go beyond the scope of the landlord's complaint, but can reduce how much the tenant owes in a non-payment rent case. So recoupment is an argument for the tenant to go back beyond when the landlord started their case. So let's say the landlord has sued the tenant for a year of rent, but they had problems in their home for 5 years. Then the tenant can go back beyond that first year to all those 5 years to argue they owe less money by reducing how much they should have paid for each of those years. Can't lead to the landlord owing the tenant any money. It can lead to the tenant owing less money to the landlord. And similarly, set off is an argument, an equitable defense arguing why the tenant should owe less money because they fixed issues and they paid money to fix issues in their home that the landlord should have fixed but didn't fix. And counterclaim is as you mentioned briefly earlier, is an option for the tenant to sue the landlord back. Under the implied warranty of habitability, they can sue back for money judgment. And the statute of limitations of that is 3 years. Or they can sue back under the theory of void lease, basically saying that the landlord owes them money for failing to repair the home. Or they can counterclaim for injunctive relief, which could be to repair the home and or to let them back into the home if they've been unlawfully removed from it. And another matter that comes up in non-payment rent cases are protective orders. In non-payment rent cases, and this is a very different version of protective orders than this term is used in other legal contexts. So in non-payment rent cases, the landlord is entitled to ask the court for protective order, in which is an order requiring the tenant pay their rent into the court registry while the case proceeds. And this is an amount that's based on, usually it's based on what the landlord alleges is the rent. So the landlord will often ask for them to pay whatever the rent is going forward. It isn't the rent that they owe, but the landlord can't get that as a protective order. But prospectively, the landlord could ask to have the tenant be required to pay going forward that rent into the court on a monthly basis. And if the tenant fails to pay this amount, the landlord can file a motion asking for sanctions, which can lead to a tenant losing their jury demand or having their defenses struck. However, a tenant can argue that they should pay less than whatever the landlord is asking for if there are housing code violations or other reasons to dispute the rent level, such as an unlawful rent increase. And to do that, a tenant can ask for a bail hearing. And this might happen at the initial hearing. This might happen at the further initial hearing. And it's possible a landlord might not ask for a protective order and then later file a motion to enter one, although that's pretty uncommon in our practice. And moving from non-payment rent to other kind of eviction claims that Kay was talking about earlier, these include the tenant failed to correct a violation of an obligation of their tenancy, which usually means that they violated the lease or they violated maybe a provision of the housing code that applies to tenants. That a federally subsidized tenant violated an obligation of their tenancy requiring them to avoid criminal activity, which in the district, generally tenants have the right to correct violations of an obligation of their tenancy. If they stop the conduct, they can avoid eviction. But for some federally subsidized tenants, they don't have that right if it's if certain kinds of criminal activity are alleged. Another reason is that a different court than the Landlord Tenant Branch found that tenant performed an illegal act, or the landlord or the purchaser of the home wants to move into the home for their own personal use, or that the tenant must move out temporarily to renovate the home. And then in this instance, the tenant would have a right to go back eventually. And talking about defenses to these other eviction claims, again, if in terms of affirmative defenses, if the basis of the landlord's claim is an inter-family offense against the tenant or their child. So, for example, if the landlord alleges that a tenant violated their lease because there was a violent incident, but actually the violent incident was an incident of an inter-family offense against that tenant or their child, then that would be a defense against that case, and the landlord should lose. The landlord's claim violates the stricter federal anti-discrimination laws. So if a landlord is, say, alleging that a tenant should be evicted because they have an unauthorized occupant who's a small child who happens to be their child, that's not in the lease, then it would probably be a defense to that's discrimination on the basis of familial status, and the landlord should lose that case. Another affirmative defense in these cases is that a tenant is entitled to a reasonable accommodation for their disability. So maybe the alleged lease violation, like not cleaning up a paint spill or something like that quickly enough within 30 days, or let's say having a pet of some kind. If there's a reasonable accommodation that entitles that defendant to having that pet, maybe to meet some kind of emotional need, or that would allow that, because the disability is hard for the tenant to address, cleaning up the paint or something like that, but now with more time they can, then that would be another affirmative defense that could lead to the tenant being able to prevent the eviction, or that the violation of the lease obligation is not a material breach, that even if the obligation was violated, it wasn't so serious that it harmed anyone, or that the landlord sued in retaliation for the tenant asserting their rights, which is similar to what we talked about non-payment of rent. The tenant can argue that they asserted a right, and that's the only reason why you're being evicted. And there's some burden shifting in the statute that can help the tenant make that defense, especially in a case that isn't a non-payment rent case. Again, with substantive defenses, this is when the defense is that the landlord can't prove one of the elements of their case, and therefore they should lose. So the plaintiff isn't the tenant's landlord. That would the plaintiff should lose that case. If the plaintiff can't prove that a tenant violated an obligation of their tenancy, or prove that they failed to correct the violation of an obligation of tenancy, then that would be another defense. If we're talking about a case in which the cause of action is that a court found the tenant committed a criminal act, if the court did not find that the tenant or household member committed an unlawful act at the home, that would be a defense. If the landlord or purchaser is intending to move in for personal use, if they can't prove to the court, to the finder of fact, that they actually are intending to move into the home for their own use, then that would be a defense, and the landlord should lose. And likewise, if there's inadequate notice, if the contents of the notice are inadequate, that would mean that the landlord can't prevail on their claims. And similarly, with non-payment rent cases, the same sort of procedural defenses are available in terms of the notice being improperly served, whatever kind of notice that is, requirement documents not filed with the complaint, or the complaint being improperly served. Now I'll pass this on back to Kate to talk about the resolution of the case.
All right, thank you so much, Paul. So now we'll talk about how eviction cases get resolved. So one of the most common ways that we're seeing these cases get resolved, especially now, is settlement agreements. In non-payment of rent cases, you might see settlements that include payment plans, a lump sum payment, repairs, or even like a neutral reference letter. So, the landlord saying for the future, this tenant was here and not giving anything negative to say. The landlord can often enforce the tenant's obligations by a motion for judgment, or an application to terminate the stay if it is a consent judgment. And if the judgment is redeemable, then the tenant can still redeem their tenancy, even if they breach the agreement. They can still go in, pay off the amount owed, and avoid an eviction on the record, avoid a judgment against them. In other cases, so this might be more commonly, and from what we're going to see in LTRC lease violation cases, that might include the tenant avoiding specific conduct or the landlord changing their conduct, and again, repairs or a neutral reference. In these cases, the landlord can still enforce the tenant's obligations through a motion for judgment or for a consent judgment, an application to terminate the stay. With these cases, you don't get redeemable judgments. You'll notice that the option to redeem, even in breach, is not available in those cases most often. Judgments are what you get at the end of the case if the landlord is successful. So landlords can obtain a redeemable judgment, which is what I was just talking about, in a non-payment of rent case if they prevail on the merits. And again, the redeemable judgment means that the tenant can still redeem their tenancy by paying off the amount owed. The landlord does have to specify how much the tenant must pay. That usually comes in a Form 6. It's a notice of amount you need to, there's some phrase, notice of amount owed to redeem tenancy, I think is the phrase. We'll show you the notice if you ever need it. That's the bottom line. And landlords can get a money judgment in non-payment of rent cases, but a few things needed to happen earlier on. So first off, they needed to have personally served the tenant with the complaint way at the beginning. Or if the tenant counterclaimed for a money judgment, they would then need to assert their own money judgment. We're not seeing those as frequently, but it is something to look out for. And sometimes landlords may ask for it without actually having gone through the correct steps to get one, which is always something we can advise tenants of. Landlords in other types of cases, as I've mentioned, do not get redeemable judgments. They get non-redeemable judgments. So this is most frequently with the lease violation cases. Tenants can only prevent an eviction if they set aside the judgment, if they move out before the eviction takes place, or if they come up with a new agreement of some sort to prevent the eviction. And back to you, Paul.
Okay. So now we'll talk about evictions after judgment or dismissal before we start talking about client-centered lawyering, which is important for giving information to tenants and landlords too. And so the writ of restitution and eviction. The writ of restitution is what allows the landlord to lawfully evict the tenant from their home after a judgment for possession is entered. A landlord must deliver a notice to the tenant informing them of the eviction date no fewer than 21 days before the eviction. And this is going to happen after the writ of restitution is submitted and approved by the court. They can't do that before. The landlord can't give that 21-day notice before that happens. And by the way, this notice is generally not going to, like, the writ is on the docket, but the notice will not be on the docket generally. The landlord must provide notice by telephone or electronic communication, first-class mail, and posting at the home. And there are certain other requirements for that notice. Tenant is entitled to quash the writ and stop the eviction if the landlord fails to comply with these notice requirements. And also for 7 days after the eviction, so whenever the locks are actually changed, if that is what happens, the landlord must give the tenant access to their former home to recover their personal property. So that's the from a very high view what happens with the writs of restitution and the actual eviction. Now, what tenants can do is they can do applications to stay or quash the writ. This is the way that a tenant can intervene to prevent that eviction from happening. And also, a landlord themselves can just stop the eviction from happening. Even after they give the notice, they don't have to do the eviction. But if a tenant can get the court involved, the application to stay the writ is how the tenant can get the court involved to stop an eviction from occurring. The tenants may file an application to stay the writ to restitution to stop scheduled eviction. If they prevail, the writ will be quashed, stopping the scheduled eviction. If they prevail on the application at the hearing, then there'll be a hearing set on that application after they file it. After the writ is quashed, the landlord will need to have the court issue a new writ. And the court may quash a writ for a variety of reasons, including that a default judgment should be vacated or the tenant will redeem soon. The court must quash the writ, as we've talked about earlier, if the tenant has a pending emergency rental assistance payment application. And defaults judgments are one of many ways in which a judgment may be entered against the defendant or would expedite getting a judgment against the defendant in a landlord tenant branch case. A default may be entered against a tenant if they fail to appear at a hearing or a trial. A default judgment may be entered against a tenant when they have not made an appearance in the case after the landlord files a Service Member Civil Relief Act affidavit. And if there's it's a non-payment of rent case, also they'd have to file that notice of the amount required to avoid eviction as well. A default judgment may be entered against a tenant if they fail to make an appearance after the initial hearing, after the landlord prevails at an ex parte proof hearing. So basically, a hearing where the landlord has to prove their case, but it's often much easier for them to prove their case because it's only them presenting evidence. The tenant basically can't raise any defenses, even if they do go to that hearing. And so, and the ex parte proof will often be set for a date after the default was entered, unless the default was entered at trial. And so the way for a tenant to get out from under a default and basically be able to assert defenses again in their case and get their case back on track for adjudicating on the merits and all the leverage they can get through trying to negotiate, like going through that process of litigation, is that they may move to vacate defaults and default judgments. And the test to show that is that the tenant shows that they did not willfully neglect to litigate the case, that they may assert various defenses demonstrated in a verified answer, which is attached to the motion. They do not unduly delay in filing the motion. They bring the motion in good faith, which basically means they're not lying about the other elements. And any prejudice of the landlord is outweighed by other factors. And the prejudice of the landlord isn't the prejudice of having to actually just litigate the case on the merits. There has to be additional prejudice beyond that. And likewise, the landlord can have their case dismissed for failure to prosecute if they don't show up for a hearing, and they can move to vacate dismissal if their complaint was dismissed for failure to prosecute. And they must file a motion to vacate the dismissal within 14 days, and they must show good cause for the case not being dismissed. And last, before we talk about client-centered interviews, DC has various laws related to sealing eviction records. And so, as we can see on the left, the court will automatically seal resolved eviction proceedings 30 days after resolution of the case if the landlord does not secure a judgment for possession. So if a case is dismissed, or if it's resolved through a settlement agreement, or if there's a judgment finding that the tenant should, or if there's a resolution on the merits and it's found that the tenant prevails in all those situations, then 30 days after, the case will be sealed automatically. However, if a judgment is entered against the tenant, either they lose that judgment's entered against them at trial, or there's a settlement agreement that has a judgment entered against them, which is a form of settlement agreement that landlords do try to get sometimes, or settlement agreement's entered and then there's a breach and a judgment's entered against the tenant. In all those situations, the case will only be automatically sealed after 3 years. However, even if a case is not going to be automatically sealed within 30 days, the tenants may still move to seal all records of an eviction proceeding if the tenant could show the following: and then here you can see the various factors. The landlord was sued for less than $600. The tenant was evicted from a subsidized home. The eviction suit was brought in retaliation against the tenant. The landlord failed to timely correct housing code violations. Protections related to domestic violence, dating violence, sexual assault, or stalking applied at the eviction. The settlement agreement did not give landlord possession, or the court finds other reasons to seal. And this is in these kinds of cases are cases that the Advocacy Justice Clinic often takes and can help people with this process. So we refer some of these cases to the Advocacy Justice Clinic as well. With that, I will hand this back to Kate to talk about client-centered interviews.
Great. All right, so to wrap up today's training, we're going to be talking about how we can make LTRC interviews client-centered, and then we're going to do a brief practice interview. So what is client-centered lawyering? Client-centered lawyering is a holistic approach that takes into account the client's unique goals and situation in life, puts aside our implicit biases, and factors in the client's lived experiences. So I know we talked a lot about the difference between legal information and legal advice. And even though we're only giving legal information, that doesn't mean that we can't approach those who come into LTRC from a client-centered focus. And in the context of interviewing community members in LTRC, that means listening to the person's goals and situation, putting aside your own biases, and being curious about their lived experiences and any other context they can provide. Because even though we're only giving legal information, that context is really important to what legal information we can provide. Now, what is implicit bias? Since I just said we want to be putting it to the side. Implicit bias refers to the brain's automatic instant association of stereotypes or attitudes towards particular groups, often without our conscious awareness. We all have implicit biases. I do, Paul does, we all do. Nobody is saying that nobody does. But it's important to acknowledge and recognize our biases so that we can prevent them from causing harm in our interviews and information providing. So how do we remain client-centered in interviewing in LTRC? Practices that we want to avoid are making assumptions about a caller's facts, values, or goals, making judgments, substituting our own values and goals for the caller's values and goals, or shutting down a caller's narrative or their expression of what's going on. And what we can replace those with is encouraging the caller to share about their goals, share about their values so that we can give them the right information, expressing empathy, questioning our assumptions as they come up. You know, you can do that in the call in your head, you can do it later on, but just question any assumptions that come up and center the provision of legal information on the caller's values and goals. All right, so now we have a little model interview. I know this is very, very tiny text. Paul, if you want to play the role of client, we can just read through these. So this is typically how we would want an interview to go here. So you'd start off by saying, hi, nice to meet you. My name is Kate. I'm a volunteer attorney with the Landlord Tenant Resource Center. I'll be talking to you about your legal issues and then going over legal information relevant to your issues.
Thank you so much. My landlord is trying to kick me out because I have a service dog. I can't believe it. I'm so upset. This isn't fair. I really don't want to move because of something that's not even my fault.
Well, I'm so sorry to hear that. That must be very stressful and frustrating. Can you tell me a little more about your service dog?
Oh, he's so sweet, so well behaved. You would never even know I had him.
Did you ever talk to your landlord about him?
Yes, I actually went to my doctor and got them to write a note explaining why I needed him.
A tenant in your situation actually has arguments for why their landlord should lose their case. So I'm going to get a copy of our checkbox answer and we can fill that out together. There we go. There's a sample conversation of how that can go. So you're seeing that the client is very frustrated. They've got this landlord who's trying to kick them out, all because they have a service dog that they already communicated with their landlord about. We have the resources available, but we want to make sure that we investigate the client's situation, right? Because if we didn't know that the client had already sent the copy of this note to their doctor and already gotten all of these other things involved, we might not have known that they have viable defenses. So you can see how expressing empathy, asking questions, remaining curious gets us to even better legal information for each person that comes in.
And I think thank you so much, Kate. I think that means that we're at the end of the presentation. So if anyone, I don't know if anyone has any questions for us. I'm also going to put does anyone have any questions for us right now they'd like to discuss? Great. Well, we'll settle for a little bit. Oh, thank you. Thank you, Carla. That's very kind. And certainly I'll put my email, and you all know our emails, but I'll put email in the chat. And this will be recorded and shared with you afterwards. But thank you so much for coming. Kate, you want to add anything?
No, thank you all so much for coming, and we look forward to seeing you volunteer.
Yeah, thank you so much. It is
Right.
really important having you all and your colleagues help with Resource Center and provide assistance to tenants and landlords. Otherwise, we'd not be getting assistance. We really appreciate it. Thank you. Bye.
Bye, everyone.